Yellow versus Venice HMA, LLC. Mr. Levenstein?
Yes, sir. Good morning, Your Honor. Late morning or early afternoon, whatever it is.
Just barely afternoon.
Yes, sir. And good morning to Judges Rothstein Yoakum and Judge LeBrit as well. Richard Levenstein of the Nason Yeager Law Firm in Palm Beach Gardens, representing Dr. Napoliello and his medical practice in this case, Your Honor. The order granting final summary judgment on the amended order of the final judgment, excuse me, the order granting summary judgment in this case should be reversed. This case is before the court pursuant to a de novo review, which we treat on page 14 of our initial brief. And we've cited some cases as to the standard of review, one of which is an appellate court must consider the evidence contained in the record, including any supporting affidavits in the light most favorable to the non-moving party. If the slightest doubt exists, summary judgment must be reversed. And we've cited.
Are there, excuse me, Mr. Levenstein, my read of this record is there's no real fact issue here. Is there?
Well, it's the application of the facts and the documents and evidence that the court reviewed in this case and how the trial court applied them to reach the summary judgment that we are challenging. And that evidence that was presented to the court created issues of fact if the court was going to weigh the evidence and interpret the evidence in the same way that a trial court would. And our position is that's what the trial court below did by not giving the proper weight and interpretation to evidence that clearly on its face indicated that the defendant was not entitled to summary judgment, and that if anything, the plaintiff was entitled to limited summary judgment with regard to the difference between what Dr. Napoliello was offered for the on-call services as the hospital's position concerning fair market value, and what he contended was the fair market value of those services that were to be provided. And it's important to note in this case, Your Honors, that Dr. Napoliello had provided on-call services in the past to the hospital without any dispute or difficulty with regard to the amount or why he was providing those services, which was to directly benefit the hospital by covering its emergency department for unassigned patients, meaning patients who either walked in off the street into the emergency room, were brought in by ambulance, or otherwise presented without referrals by a treating or primary care or other physician, and through the emergency department was referred to the physician on call in the particular specialty, in this instance, general surgery, for treatment, most of which are indigent patients or uninsured patients who either have no insurance coverage to pay for those services or minimum coverage at best. So that was the situation that was in effect before the dispute in this case between the parties and continued afterwards when Dr. Napoliello continued to provide the coverage. The only issue in dispute between the parties was what the fair market value of the services were. And in both parties' briefs at page 7 of the appellant's brief, initial brief, and page 5 of the answer brief, we quote the same language from a letter sent by the hospital's chief executive officer to Dr. Napoliello stating, "We are only able to offer compensation for providing on-call services for our emergency department at a fair market value rate."
And that's because the Stark law requires that the hospital only pay a fair market rate for those services. And the CEO or whatever CEO person it was also said that this is what we can pay you, and if you don't agree to this, then you're not going to get paid.
Right. And
isn't that what the letter said?
That's what the letter says. However,
and your client kept working.
He did. And the Stark law works both ways. In other words, if fair market value is not paid by the hospital to the physician, and the physician accepts it, and there is an audit by the Office of the Inspector General, or HHS, and fines are levied for not paying the fair market value for those services. The physician is liable for the fines as well as the hospital.
But this case doesn't, there's no Stark violation here, and at least none alleged. And under the scenario that you're describing where the physician shows up and works for free, the OIG would probably go after both the hospital and the physician, but we don't have that. The Stark really is a backdrop here, isn't it?
It's not a backdrop, Your Honor.
Why not?
Because the fair market value concept is what is required by Stark. The hospital says that the fair.
Are you saying that the hospital violated the Stark law in this case?
If it did not pay the fair market value of those services, absolutely.
Was that alleged in the complaint? Is there a Stark violation?
It is alleged in the complaint that the Stark law required.
Does violation of Stark afford a private cause of action?
It does not afford a private cause of action, but it certainly imposes.
Is the Attorney General a party to this case?
He is not, Your Honor, but it imposes liability.
So the Stark at best is wallpaper for what the dispute was over the pricing.
No, sir. No, ma'am, it is not. If Stark did not apply and did not impose liability upon the physician as well as the hospital, and this was a matter of the price without a statutory and regulatory framework governing that fair market value requirement, I would agree with you. But that is not the case here. Dr. Napoliello wasn't saying he wanted to be paid a certain amount of money. His position always was that he would provide the service. He offered to sign the contract if they would allow him to simply challenge the amount of the fair market value.
But he wanted to be paid a certain amount of money, and it was more than $635.
Because he believed that under the Stark regulations, he was entitled to and must have been paid at a fair market value rate, because that's what the law required, and that's what.
But then he kept working.
Yes, ma'am.
And he knew that the hospital didn't intend to pay. By your answer, I don't think that he either did or believed he could allege a violation of the Stark law by the hospital as part of his claim against the hospital for what I believe is unjust enrichment and only unjust enrichment.
He did.
Am I right?
We did allege that the Stark requirements, the Stark statutory framework required the hospital to pay fair market value.
That's not my question. I have some experience with Stark. My question, and what I want you to acknowledge, is that there's no private cause of action for a hospital's violation of Stark by a physician, and that couldn't be part of the relief or the theory of liability here.
It could not be part of the liability, but it governs the relationship between the parties and the unjust.
I don't disagree with you, so you don't have to beat that horse all the way to death. I'm just trying to crystallize the legal issues that you want us to review, which I believe boil down to the unjust enrichment finding.
It is on
lack thereof.
It is. Our claim is for unjust enrichment because Dr. Napoliello provided a service that he had provided in the past. He agreed to provide the service. And the only issue was what was required by law to be paid for that service. He agreed to sign a written contract for that call pay, and if he had the right reserved to challenge the amount. And you'll find that confirmation in the deposition of Kristen Gentry, which is in the record at pages 103 to 105. And in particular, when I asked Ms. Gentry.
So let's focus on the legal part of this, which is what the trial court found and what you're asking us to reverse. Yes. And it is that the trial court found as a matter of law that, or held as a matter of law, concluded as a matter of law, that your client continued to perform services essentially at his risk, given that the hospital had told them that he wasn't going to be paid, principally relying on the Hermanowski case and I believe the officious intermeddler doctrine. So tell us why the trial court was wrong on the law.
The trial court was wrong on the law because the hospital had the ability to pay my client for the services that he provided without a written contract. And that's acknowledged in their letter from their counsel.
Well, they had the ability to pay, but your client wasn't agreeable to the amount they were willing to pay.
Right. They continued to accept the services that he provided for their benefit, allowed him.
But didn't the agreement between your client and the hospital, the hospital could not have unilaterally prohibited your client from rendering those services, correct? I mean, what were they supposed to escort him out every time he walked in? Should they have barred the doors? I mean, what could they have done to prevent him?
He had an obligation to take call pursuant to his medical staff bylaw contract with the hospital.
And he could have resigned from the staff under the bylaws if he had chosen, if he had another hospital that would pay him $750 a night to take call, couldn't he?
That was
Nothing was making him stay on staff.
But that also would have eliminated his ability to dispute what the fair market value of what was being offered and what was being required to have been paid, and would have forced him off the staff of the hospital. And this is an equitable case, and that certainly would not have been an equitable result.
So let's talk about equity then. I don't think either of you briefed it, but hopefully you're familiar with the 2018 decision of the Third District Court of Appeal in Duty-Free World, Miami Perfume Junction, where Judge Vincent Lagoa, subsequently our Supreme Court Justice, very carefully parsed out what unjust enrichment is and concluded that when the plaintiff is seeking money, this isn't equity, it's law. And so the equitable considerations associated with whether your client could or should have resigned from staff are, to me, extraneous. Your client wants money for work that he did that the hospital said they weren't going to pay him for. And your position on the equity is essentially most of the patients were either un or underinsured, so he may not have been getting paid directly. What I'm struggling with here is how we apply the law, the doctrine of unjust enrichment, to a situation where you essentially have an officious intermeddler who is providing services that the hospital really can't unless if he resigned from staff. Certainly they're going to keep him out of the ER. But as long as he's on staff and he knows he's not getting paid, the hospital is not voluntarily accepting a direct benefit. They're doing what they said they were going to do. Leave him on staff and you're not getting paid for on-call.
But that ignores the fact and the obligation on the hospital to have paid Dr. Napoliello for the services that he provided when he offered to sign the written contract that they said was a prerequisite to payment, and accept the 635, if he was granted the right to challenge the amount of the fair market value.
Which is a counteroffer.
I'm sorry.
Under the law of contracts, that is a counteroffer. That's not he's not really accepting the contract.
Absent the statutory framework and regulatory framework of Stark, I would agree. But under Stark, because Dr. Napoliello was subject to the Stark potential liability of accepting an amount that would be not fair market value.
If Dr. Napoliello was worried about the hospital violating Stark, Dr. Napoliello could have resigned staff. The reason he wants to stay on staff is to be able to use the operating room to perform general surgery on insured patients during the day. And the trade-off in the bylaws is anybody who's going to use the hospital for their privileges to operate on insurance patients has to take call. So your client didn't resign because he figured eventually he would get the hospital to pay him something like what he wanted. Isn't that right?
He took the call because that's what he had done in the past, pursuant to the contracts he had signed with the hospital. He took the call because it was part of his obligation as a member of the medical staff. Certainly, if he generated any income from taking call, which was a rare occasion, and all the other physicians were subject to that same benefit if they received it, he would receive some benefit from that. But historically, that is not the case. Historically, those patients are almost all indigent, which is why the Office of the Inspector General allows call pay, because the hospitals have a difficult time.
Allows, but doesn't require.
It allows them to when they are not able to obtain the services of on-call physicians to cover, and as a condition of EMTALA. And
we don't have any evidence that this hospital wasn't able to obtain the services of physicians that weren't able to cover.
That's not an issue here. I'm just going.
Well, then you went there.
I went there only because of the background of the on-call pay history with the OIG, because in the past, before the Office of the Inspector General's opinions were rendered, call pay was prohibited and physicians were not paid for being on call, and they took the call as an obligation. But when call pay is triggered under the Office of the Inspector General's opinion 12-15, fair market value must be paid. And it's a two-way street. It's not just that that the hospital would be violating Stark by paying less than or more than fair market value. Dr. Napoliello would also be on the hook for any violation of Stark for receiving it. And he made that clear to the hospital on multiple occasions. And it's in his deposition.
You're putting your guy in a corner there, because if he thought he was violating, if he thought that he and the hospital were in violation of Stark by his working there for free, he had something else to be doing than keeping working for free.
You did not.
I'm sorry, I cut off Judge Northcutt.
Well, I was going to say, Mr. Levinstein, you didn't mention whether you wanted to reserve rebuttal time.
I did.
You're down to 5 minutes. And so
I think I should reserve. I think I need to reserve the time then for my.
That's fine.
Thank you, Your Honor.
Hey, Mr. Coe.
Thank you, Your Honors. Jason Coe on behalf of the Appalachia Venice Regional Bayfront Health. As we argued in our brief, the law of contract is superior to the law of restitution as an organizing principle of private relationships. When two parties have the opportunity to negotiate for the provision of services and they're unable to reach an agreement for those services, there is no cause of action when one party takes it upon itself to render those services. There's no cause of action in unjust enrichment. Allowing that would be an end run around the traditional contract rule that a rejected offer is a dead offer. And that
so, Mr. Coe, cut you off.
Please.
I just gave your opponent, I'm sure, too many questions on the Stark issue. Can you speak to that from your perspective? Is your client, by letting Dr. Napoliello continue to show up for call in the ER and not paying him for that, Stark doesn't really like that. And so please address the Stark issues as far as whether your client had some independent obligation, apart from the contract issues that we're discussing, to pay your client whatever he thought was fair market value.
I'm happy to, Your Honor. So the first thing I'll say about Stark, Mr. Levinstein said that it works both ways, but Stark is a cap and it's not a floor. And you see this in the OIG opinion, and you see this in traditional principles of hospital reimbursement. Hospitals are not required by Stark, by anti-kickback, or by any other law. They're not required to compensate physicians for taking call. That's the first point. So the second point then is Dr. Napoliello, if he receives no payment, or if he receives less payment that's less than the fair market value, he is not in violation of Stark, and neither is the hospital. The only violation of Stark occurs if the hospital pays a physician more than the fair market value. And the reason for that, of course, is Stark was designed to prevent the situation where you're disguising payments for referrals as
and so viewing the evidence in this record most favorably to Mr. Dr. Napoliello, where the Stark law leaves him is that he was asking for something that the hospital thought was above fair market value.
That's correct. And that's one of the reasons why the hospital wouldn't agree to the payment that he demanded. And that's why the hospital made its offer, and its offer was consistent with fair market value in the hospital's view and supported by an expert appraisal. And the record also shows that all of the other physicians who were practicing in general surgery and taking call at the hospital in that specialty accepted the rate that was offered to Dr. Napoliello and signed written agreements, and they worked.
So from your perspective, for the hospital to have acceded to Dr. Napoliello's $750, the hospital would put itself at risk of a Stark problem.
Yes.
That's you got there much quicker than I was able to articulate the questions. Yeah. And I'm happy to let you off the Stark hook now if you would like.
That's correct. And we did make that argument below. And I'll get to the point in a second that I think this case, Stark doesn't really need to enter into this case. But we did make that argument below because I think there might be a problem if the state law of unjust enrichment, if Dr. Napoliello were to succeed. If the state law of unjust enrichment then mandated that the hospital pay more than fair market value, then there might be a conflict with Stark and AKS, a conflict between state law and federal law. But as a matter of what the trial court held below and why the trial court granted summary judgment, it was strictly a matter of the standard contract principle that if parties don't agree, then one party can't render services and sue an unjust enrichment. And it was also just a straightforward application of the law to the undisputed facts in the record as to the elements of the unjust enrichment claim. So, I think Mr. Levenstein's comments about Stark are misguided and incorrect. But I also think that your observation that it's something like wallpaper in this case is also correct. I don't think you really need to analyze the Stark issue. And Stark certainly does not convert an otherwise rejected common law, state law offer into an obligation to pay on-call physicians in unjust enrichment. So, I'm not sure that there are a whole lot of other points that need to be addressed. Just touching briefly on the elements of the unjust enrichment claim, the trial court correctly held under the undisputed facts in the record there was no direct benefit by the plaintiffs rendering call services, medical services to the patients. As your honors observed, there was no knowing involuntary acceptance of the benefit. The hospital clearly indicated that it would not pay the plaintiffs for the services. And the plaintiffs nevertheless demanded to remain on the call schedule. And the bylaws would have prevented the hospital from unilaterally removing them from the call schedule. And then I think also as a matter of the unfairness of compensating plaintiffs, they were compensated for the services they provided by the patients and their insurers directly. And under the circumstances where there was a clear warning that they would not be paid, there's no unfairness in denying compensation here.
Be clear, Mr. Coe, in this circumstance where somebody who's actually got Cadillac insurance shows up in the ER and is treated by a general surgeon, say Dr. Napoliello, for purposes of this hypothetical, Dr. Napoliello is going to be compensated by that insurer in accordance with the standard rates for the services he would perform while on call. Am I right?
That's correct. And that's precisely the argument that we're making in accordance with, I think, the well-reasoned and well-worn principle that where someone renders services hoping to make a profit for themselves, that cuts against any finding of unfairness for not compensating them in unjust enrichment. So, Your Honors, I think you understand the arguments that are being made. And if there are no further questions from me, then I'll go ahead and rest on the arguments that I think we've clearly laid out in our briefs. I thank the court for its attention, and we're asking that the court affirm the summary judgment.
Thank you, Mr. Coe. Rebuttal?
Yes, sir. Thank you, Your Honor. The Inspector General opinion that governs this issue states that payments for referrals, such as alleged by Dr. Napoliello, that other physicians who were on this call schedule and took the lesser amount, such as recruitment agreements and subsidies, would be a violation of that opinion and those regulations. And therefore, Dr. Napoliello received disparate treatment as compared to them because he received no such subsidies in recruiting agreements or otherwise. And that's alleged in our complaint. So that would be something that would be the trier of facts issue to determine, because that is an issue that would go to whether or not the compensation was actually fair market value. Under the scenario that Mr. Coe has painted for the court, this is a one-way street, this fair market value. The hospital determines what it is, and either the physician accepts it or there's no alternative, which is what Dr. Napoliello is faced with. The Office of the Inspector General opinion states that it must be commercially reasonable and must be a fair market value, as the OIG requires that to be determined, with an independent appraisal and not taking into account whatever income would be generated otherwise by the physician from patients who paid. So that element of what Dr. Napoliello would have received is not part of this analysis, and it's not part of the OIG's analysis. As far as a direct benefit, the hospital, in a document attached to our response and in evidence, made a calculation that the cost of these contracts was in the low hundreds of thousands of dollars, and the benefit to them directly from the contracts was in the multi-million dollars in revenue because of the technical components that were generated by these patients and the subsequent treatment of those patients by the hospital. That is not an indirect benefit. My client was not rendering that service for the patients other than being their treating physician. He was rendering that service for the direct benefit of the hospital he had a contract with to provide that service. So the indirect benefit theory flies in the face directly of the evidence which we submitted. If the hospital performs a cost analysis that strictly and clearly depicts what their costs are of these services and what their revenue benefit is, they have to be bound by that. The trial court determined independently and without any other evidence that that was an indirect benefit, but on its face, it is a direct benefit. And lastly, because the hospital is required to provide emergency room coverage for service lines for which they provide care for patients, pursuant to EMTALA and its state licensure, this service that my client and the other physician rendered was a direct benefit to the hospital, was not an indirect benefit of any kind, was a benefit to the patients because they received the treatment, but the hospital benefited directly, as I stated before, from those patients being treated by these physicians covering the call. To not allow Dr. Napoliello to be paid at least the $635 that the hospital determined was the fair market value of the services which he provided and which he continued to provide is unjust. And when Judge LeBrick, when you talk about it being a money claim, it is a claim for money, but it certainly is a claim for money that is governed by and regulated by a statutory background of the Stark and other regulations we discussed earlier. And Dr. Napoliello offered to sign the written agreement subject to a challenge of the amount, was denied. And the hospital admittedly had a way to pay him without having a contract when they offered to do so by a one-time isolated payment, which is permitted by Stark without a written agreement at the same rate of $635. But they never tendered that amount to him unconditionally. And we therefore believe that the hospital was unjustly enriched and summary judgment should be reversed, in this case, be tried to its merits. Thank you.
Okay, thank you both very much. You can leave by hitting the leave button in the lower left-hand corner of your